Hello, and welcome to Gateway to Privacy, a podcast from global law firm K&L Gates, where we discuss the latest developments and best practices in today's data protection, privacy, and security industry. We hope you enjoy this discussion. Please reach out to suggest topics or guests, or with questions about data privacy law.
Welcome to the Gateway to Privacy podcast. Today, your hosts are Jake Bernstein. I'm a partner in the K&L Gates Seattle office, and Whitney McCollum, also a partner in our K&L Gates Seattle and San Francisco offices. We are both technology transactions attorneys and certified privacy professionals. Hey, Whitney.
Hi, Jake. Today, we are fulfilling promises we made in episode 2, and we will be discussing the Federal Trade Commission's, or the FTC's, role as the de facto national privacy enforcer.
Doesn't the FTC do antitrust and consumer protection? How are they involved in privacy? And in fact, didn't we say last time that there is not a national privacy law in the US?
Great questions. And yes, we did. And yes, they do antitrust and consumer protection. The FTC uses its incredibly broad authority under Section 5 of the FTC Act, which prohibits unfair or deceptive acts or practices in commerce. They use this authority to regulate privacy and cybersecurity. Section 5 of the FTC Act is the same law the FTC uses in all of its consumer protection investigations and cases, and that really have nothing to do with privacy, at least not directly. This means that the FTC believes that failing to protect personal data is an unfair business practice. Jake, why is that?
Well, Whitney, I'm glad you asked. The definition of unfair can be found in Section 45N of the FTC Act, and it wasn't always this way. This was a codification of case law that came about in the last, I want to say 30 or 40 years. But the current definition of unfairness is a practice that is unfair if it causes or is likely to cause substantial harm to consumers that those consumers acting reasonably cannot avoid, and this, I've, to be honest, never understood this element, is not otherwise outweighed by countervailing benefits to consumers or competition. And I'll just editorialize here. I think that last element is there to give the FTC the flexibility to consider the full facts and circumstances in any given business practice. Sometimes something might cause harm to consumers that they cannot reasonably avoid, but it's good for them or competition somehow. And I don't know that I've seen an example of that, but it does in theory exist. Now, with a data breach, the idea is actually pretty straightforward. If you think about it, once you give your data to a third party, and as long as it was reasonable to give your data to that third party in the first place, which it almost always is, then there's nothing you can do as a consumer after that to protect your data. You are 100% reliant on that business to safeguard your information. So, and if there is a data breach, well, that is a possible substantial harm that has no other benefits.
That's a frightening thought, given the amount of data that we are sharing. And it's interesting, and we'll get into this more as we discuss what is considered a harm to consumers. And the FTC builds on that a lot, and we'll get into some of the landmark matters. But I think what's really, really interesting about all of this is that the word privacy appears nowhere in the FTC Act. Have courts approved this apparent expansion of the FTC's powers?
That's quite a bit more complicated. And as I am apt to do, I'm immediately going off script because you made a comment about harm. And I want to take a moment because we have a lot of lawyers hopefully listening to this podcast. And I think the question that a lot of people raise, and that has been a major issue in data breach cases brought by private parties, is the concept of Article 3 harm, right? Damages. And it's often been I'll say a roadblock or a barrier to successfully bringing class action lawsuits, for data breaches. The FTC, though, we just said it is the standard isn't, causes Article 3 harm. It's causes or is likely to cause substantial harm. And I think that the FTC has been able to some degree, avoid some of the same pitfalls that private parties have not been able to avoid in that. So with that brief interlude into constitutional law, I will move back to the question. And your question was, have courts approved this expansion of the FTC's powers? And, on one level, yes. In 2015, the Third Circuit basically approved of the FTC's authority over data breaches in the Wyndham Worldwide Corporation case. I believe it was Wyndham Worldwide Corporation versus FTC at the time. And that was a clear win. Like, there's really no caveats to that one. The Wyndham Corporation is a hospitality company, very large. They didn't really have any cybersecurity at all, which makes it not the greatest case in terms of like useful precedent in order for people to figure out what to do, because they were so bad that like nobody's going to do that. Nobody these days, especially, is going to have such poor security. So, but nonetheless, the FTC won, and things were a little quiet for a few years after that. But it's also had some mixed results. For example, and we don't need to talk about it on this episode, but there was this shift in the language of FTC consent decrees in this area from, basically thou shalt have a reasonable cybersecurity program to thou shalt do the following at a minimum, which I call the at a minimum standard. And the reason for that change is the FTC's loss in the LabMD case before the 11th Circuit in, I want to say 2018 or 2019. And the issue there was that the 11th Circuit decided that the FTC's, at the time, standard consent decree language, which is reasonable cybersecurity, was too vague for an injunction, because that's what a consent decree is, right? It's a settlement. And that really forced the FTC to rethink its language. So it's not necessarily as simple as saying that the FTC is the nation's de facto privacy or cybersecurity enforcer, because they are operating in an area that they may not always win. More interestingly, though, is the fact that, is it privacy or is it security that they're enforcing on? And I don't know that it's that clear. Most of the cases that we see are really about data breaches. And I think those are arguably more about a security failure, which leads to consumer harm, rather than some more abstract violation of privacy rights. And I don't know, Whitney, do you think this is a distinction without a difference? Or is it important for us to note that the FTC really can't bring an investigation if a company refuses to delete someone's personal information, particularly in a state without a comprehensive privacy law?
I think it's not a distinction without a difference. I think it's important for us to recognize the barriers to FTC's ability to act on behalf of consumers and on behalf of privacy. It is quite limited, and we don't have the lines in place to require companies to do the more minute things with data that we've come to expect and want companies to do. And so as we can see through these enforcement actions, they're trying to create bounds, and they're being incredibly vocal about this, but their hand is limited right now to Section 5 of the FTC Act, which is so short. And so, as you mentioned with the Wyndham case, well, they didn't have any cybersecurity in place, but now companies are expected to, because they've set this kind of floor for cybersecurity. But we don't want a floor. We want something more.
We do. And the FTC has found a way to get that something more, but it does that with its kind of classic deceptive practices enforcement authority. And this is actually pretty intuitive. Essentially, the FTC has been able to go after companies who either don't abide by their own posted privacy policies, or whose posted privacy policies don't reflect reality. This falls under like misrepresentation and misrepresentation by omission, respectively. Pretty straightforward there for the FTC's Consumer Protection Authority. And this same argument is often used or has been added to security enforcement actions, where particularly a defendant has made affirmative representations about the quality of their security, let's say, that have been proven to be false. So that is the only way, really, that the FTC can get at pure privacy practices, is if the company is not posting something that's true, or is posting something that it does not reflect what they're doing.
So this really helps explain why we say de facto privacy enforcer, doesn't it? Because in reality, the FTC doesn't actually have a privacy law to enforce. But what about rulemaking? Hasn't the FTC been quite active in trying to make rules about privacy, essentially creating new laws without congressional action?
Yes, it has. And it's going to be really interesting to see how this all plays out. So actually, way back in 2021, there was a hint that the FTC might consider Magnuson-Moss rulemaking. And then in 2022, it really did begin what is a rather arduous process under this Magnuson-Moss rulemaking authority, which I believe can take up to 6 years, maybe even longer. So just to give a bit of history here, in April 2022, the FTC issued a press release to announce its intent to begin rulemaking to, quote, address privacy and cybersecurity deficiencies. And then it kind of went a little silent. In August, it published additional information on its plans, focusing on, quote, commercial surveillance and lax data security practices, which culminated in September 2022 with the FTC holding a, quote, commercial surveillance and data security public forum, which is not random. This was required by the Magnuson-Moss Warranty Act. And you might be wondering, if you're a lawyer who's familiar with the Administrative Procedures Act, what is going on here? What is Magnuson-Moss rulemaking and why is it relevant at all in this discussion? And the answer is actually quite interesting. So throughout the 70s, the FTC, let's just say, made quite a few unpopular rules. And there's no polite way of saying it. Congress clipped its wings with the Magnuson-Moss Act. And in fact, they made the rulemaking process under Magnuson-Moss so, onerous precisely to discourage the FTC from engaging in rulemaking. They didn't have to do that. They could have. The FTC does have standard Administrative Procedures Act rulemaking authority under certain acts, but it doesn't have super broad rulemaking authority. For example, it has rulemaking authority under CAN-SPAM, under the Children's Online Privacy Protection Act, the Gramm-Leach-Bliley Act, and a handful of others. So up until now, which is, I think the Magnuson-Moss was late 70s, early 80s. So in the last 40 or so years, the FTC really hasn't made any broad rules. And now the FTC is looking to do it. Why are they looking to do it now? It would be an historic event. And, Whitney, we don't know much of anything what these rules would actually look like. The FTC hasn't released any kind of draft language, and many pundits, which I think we are right now on this podcast, expect that the FTC is doing this, I think at least in part, to encourage Congress to act and pass a national privacy law. And if Congress doesn't act, then 6 years from now, maybe we'll actually have privacy rules.
Agreed. I see this as the FTC saying, come hell or high water, we're getting a national privacy law. And if we have to go through this long, painful process to get something in place because Congress is not getting it together, then we will. I think the history and evolution of the FTC as an enforcement authority is fascinating and obviously not something we're going to get into detail into today.
Or probably ever.
Ever. Yeah. That's for someone else's podcast or for, a law review class or law review article that I will be happy to read or take. But I love, as a privacy lawyer, I'm very much enjoying this time that we're in right now of the FTC doing what it can within the boundaries that it has of getting a law in place that it knows absolutely needs to be in place. And so I think with all of that, let's talk about what the FTC has been doing the past 5 or so years when it comes to privacy and how they've been moving the needle and making their voice more and more heard when it comes to expectations for consumer protection around data.
I totally agree. And we've already mentioned Wyndham and LabMD, but there are, of course, dozens and dozens of other examples. Though very few have actually gone to circuit court, to a circuit court. That would be a very small number. It's might be one or two more, but the names aren't immediately coming to mind. What the FTC has in droves, though, are consent decrees and consent orders. Same thing. And I haven't counted. I want to say it's probably getting up to close to 100. And they cover, all kinds of fact patterns, industries, various sector-specific laws, including the GLBA safeguards rule, and most recently, which we will talk about, the FTC's health breach notification rule. So let's go ahead and talk about a select few examples to wrap up this episode.
That sounds great. So we cannot talk about FTC privacy, action, and enforcement without the $5 billion Facebook settlement from 2019. That one was absolutely groundbreaking and landmark, and I think sets the tone for a lot of the privacy conversations. $5 billion is a huge number. It's by far the largest ever fine imposed on a company for violating consumer privacy, and it's nearly 20 times larger than the largest privacy or data security penalty imposed worldwide. The FTC former chair, or the chair at the time, noted that it's in line more with violations of environmental acts and wanted it to be seen as something that big.
Yeah, and I think it's worth pointing out that the lifetime grand total of GDPR fines is about, I'm going to say roughly 2.5 billion euros. So even though it's not quite one-to-one with the exchange rate, you're talking about the Facebook settlement being almost twice as large as every GDPR fine combined to date.
Which is crazy because it wasn't even based on violation of a law.
That is insane.
It's insane. It stemmed from Facebook's violations of its 2012 consent order that it entered into with the FTC that focused on Facebook's alleged efforts to undermine consumers' privacy choices in its platform. And so going back really quick, in 2012, the FTC finalized a settlement with Facebook in response to an 8-count complaint that alleged various unfair and deceptive acts, all around the theme of telling users they would not use or share personal data and then using or sharing it, or not deleting it. As part of that settlement, Facebook agreed to stop making misrepresentations about privacy and security of data, establish and maintain a privacy program, and obtain third-party privacy audits for 20 years, to show the FTC requirements are being met or exceeded.
Wow. There's a lot of, the FTC doesn't have an easy time imposing monetary fines until you violate an injunction in a consent order. And then they can go big, as they amply have demonstrated here.
Yeah. So I'm going to stop here with this 2012 settlement and note that here we are over a decade later. These requirements don't tell users you're going to do one thing with their data and then do another, and have a privacy and security program. They're seen as privacy and security foundations, but are actually now just starting to creep into the U.S. state comprehensive privacy laws, as we discussed in episode 2. So Jake, take us to 2019. What happened with Facebook?
Well, 2019, if I'm sure a lot of us recall, was the Cambridge Analytica year. And what happened was it wasn't technically a data breach because they weren't hacked. They willingly gave information to this third-party company, and it was all tied up into politics, which we are definitively not going to discuss on the Gateway to Privacy podcast. But suffice to say that the FTC and the rest of the world, I think, saw this and was like, wait a second, that is not at all consistent with what Facebook said its privacy practices were. And that led to the FTC finding the violation of that 2012 consent order. So I think that's where the $5 billion came from. That is the specific event that caused it. And I really do think that, the FTC probably wished it could have done more, but it really couldn't. And I think it's fascinating that, 5 billion was a huge number, but in terms of the enforceability, who they could name, how much farther they could go, they really are limited. And I don't know, Whitney, do you think we can talk about 2 more cases before we fully close here?
I definitely think so. And I would like to say one more thing, that I think the most interesting thing now, looking at this 2019 settlement and fine, is rewatching the press conference they had, and the then FTC chair, Joe Simmons, pointed out exactly what you said, that they were really limited in their ability because they're working with this 100-year-old law. And he said, we were only able to do a $5 billion fine. We were not able to name executives. We were not able to find them more, indicating that he thinks they should have. And then he said, this is exactly why we need a federal privacy regulation, and we have stated the same to Congress. And so here we are now, it's all building.
It is. It is definitely building.
Jake, you're going to talk about, I think, one of my favorites. I have a lot of favorites, but this is one of my favorites.
Me too. And it's my favorite for a very specific reason. So this was a couple of years ago, not that far in the past here. It was, I want to say, 2021, I believe this one was. But I'm talking about the WW International, formerly known as Weight Watchers, the settlement related to Kurbo. And Kurbo was an app by WW International that was collecting children, personal information without the parents' permission. And if you know anything about online privacy law and what little there is of it in the US at least, you probably have heard of COPPA, which we mentioned in episode 2, the Children's Online Privacy Protection Act. And it's not the strongest law, but it is pretty darn clear that if you're going to collect information from children under the age of 13, you must get affirmative parental consent. And there's a bunch of requirements that, frankly, we're not going to go into right now about it. Suffice to say that WW, via its Kurbo app, didn't bother. And what they were using the data for was to train an algorithm. And what's so interesting about, machine learning algorithms is that, that word training is very important. You don't program it. It kind of programs itself based off the data that you feed it, the algorithm. And the FTC, I think, came up with a remedy that, it has the best name ever, but more importantly, it is effective. And what am I talking about? I'm talking about algorithmic disgorgement.
It is the best name ever.
Which really is just a phenomenal name. All things aside, it's a great name for a remedy. And this remedy really goes to the heart of the matter. Now, as you know, I'm a former assistant attorney general. I did a lot of enforcement actions. I worked with the FTC early in my career. And one of the things that would drive me nuts is when a target company, an investigation, a company under an investigation or settling with either an AG or the FTC would clearly sign the consent decree or consent order and then go on as if nothing had happened. They the phrase is cost of doing business, right? We're going to violate the law and it's just a cost of doing business. This is always a problem. What the FTC wanted to do here is make this something that was not merely a cost of doing business. And what it did was required WW International to delete the algorithm itself and all the data that it used to train the algorithm that was obtained unlawfully. This is a hugely effective deterrent because all of that data and all of that training and then the end result of that algorithm are gone. There's no value remaining at all. And so there's no way for a company in this situation to kind of chalk it up as a cost of doing business, making it, for better or for worse, an extremely effective enforcement practice. Do you have any thoughts on that?
I love this action, not just because of the great name, algorithmic disgorgement, but because of the consequence is meeting the action. You're exactly right. The cost of doing business risk with data use and data mishandling is pervasive. And the FTC's ability to put injunctive remedies in place that actually match the risk and the harm done, to me, it's perfect. And going forward and advising companies on the risk of data in this landscape of what are we working with and thinking through what's fair here. this is fair. This is fair. And it's a great remedy because they didn't want this data because of the actual data or to provide the service. A lot of times companies want the data because the back end tool that they're building with it.
And the other thing I love about this case from a client counseling perspective is it really illustrates that the FTC has deep technical expertise. They've been investing in this for several decades now. And, there was a point, and there still is, I'm sure, for many enforcement agencies where, a company might be able to assume that, the technical chops for some of these agencies isn't there. Do not make that mistake with the FTC. It has significant technical sophistication, and it understands these things. And that is that's frankly just a key component in understanding the FTC, their enforcement, and how you manage that risk. Okay, so one more. What do you got for us?
One more. This one's very recent, and it's another landmark FTC case. And so this case was announced on February 1st of this year, 2023. And it included a $1.5 million civil penalty against GoodRx. And GoodRx is a digital health platform, and it offers prescription drug discounts, telehealth, and other health services. The civil penalty against GoodRx was for failing to report unauthorized disclosure of consumer health data in violation of the health breach notification rule. And that's the key point here. The health breach notification rule requires that organizations that are not covered by HIPAA notify their customers, the FTC, and sometimes the media if there's a breach of unsecured, individually identified health information. And the FTC issued a policy statement in 2021 that made clear that makers of health apps, connected devices, etc., are covered by this. So this is a big deal because for two reasons. One, it expands kind of who is covered, who uses health data and the responsibility for it. But two, it flips the understanding of what a breach is.
Yeah, I was going to ask, was there when we say the word breach, we oftentimes, assume that there's some kind of hacking involved. Whitney, was there hacking involved in this case?
There was no hacking. There was no hacking, not by a third-party threat actor, which is what we think of as a breach, or sometimes the other definition, though, of breach is improper access or sharing of personal data, which is what this was. And so GoodRx was sharing its customers' personal health information, so name, prescription, medical conditions, with third-party advertisers and other third parties, and specifically Facebook, Google.
Oh, I think it was the typical kind of stream of advertising agencies, advertising companies.
Exactly. Thank you. And so they were using this personal health information, not only sharing it with these advertisers, but then using it to send targeted ads on other platforms to its customers. They also didn't limit how these third parties used their own customers' personal information. And so really, it's an unauthorized sharing of personal information. They didn't get authorization. They didn't provide notice to their customers that they were doing this. So the classic definition of breach has now been expanded to unauthorized sharing of health information with third parties.
It's so fascinating simply because I would bet, and we don't know. I don't believe. I don't know who is involved on their side with counseling them. But as a business, I bet they had to have been surprised that the FTC was investigating them for something called the health breach notification rule when there was no hacking of any kind. Just absolutely fascinating to me the way the FTC has used this. Also, it's also the first time they've ever used the health breach notification rule. I think you mentioned that, but just to really hammer that point home, this is the modern FTC. They are willing to break new ground in the privacy sphere. And, we could have a long debate about whether or not they should be doing this, in the absence of congressional authority and clear congressional intent with a, actual privacy law. But it almost doesn't matter because they are doing it. And, when we counsel our clients, this is a big part of it. Like, this is what is happening, and our clients need to know.
Exactly. And they're setting standard expectations for how consumer data should be handled, which is going to feed into, hopefully, federal privacy law creation and enforcement.
I very much agree with that. So let's go ahead and wrap up this episode of the Gateway to Privacy podcast. We hope you enjoyed learning about how the FTC acts as the nation's effective de facto privacy enforcement agency and how it has interpreted and expanded its authority in this area over the past several decades. We'll see you next time.
Thank you for listening to this episode of Gateway to Privacy. To listen to past episodes and receive notices for new episodes, subscribe by searching Hub Talks. That's HUB Talks in your favorite podcast app. Tune in next time for more data privacy insights.